I have it. I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're
Then
also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not
but
wasting any more time on it. We are done.
Buckle up, guys. We're jumping right into a courtroom showdown where the self-proclaimed sovereign citizen thinks he can outsmart the judge. Right from the opening words, you can feel the tension. The judge sees straight through the nonsense and makes it clear no time will be wasted today on bizarre claims or fake laws. This first exchange sets the stage for all the chaos about to unfold in this legal circus.
Travis, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent all documents except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure and, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last.
Guys, watch closely as the man tries to dodge even the simplest questions. The judge asks whether he got the documents, and instead of a straight answer, he rambles about emails and missing paperwork. His strategy? Confuse the facts just enough to stall for time. But as you'll see, the judge is having none of it. This awkward back and forth shows exactly how weak his so-called defense really is.
Payment, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
Chavez, you're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender and they borrowed from me.
What did they borrow from you? No, I'm not buying that. No. Listen to me. Listen.
It's not about. I have it. I'm going by the law, Your Honor. I'm not just making up anything.
No, you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card. And you didn't pay on the card.
This is where things get wild. When pressed for his defense, he suddenly claims he's the lender, not the borrower, flipping reality upside down in front of a stunned judge. He talks about accuracy and accounting, but none of it makes sense legally. This is classic sovereign citizen spin. Twist basic facts into a bizarre theory, hoping the court gets lost in the fog. The judge, though, is about to clap. Back hard.
They don't owe you anything.
So when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
The narrator and judge both step in to cut through the nonsense. You can feel the judge's patience slipping as he explains, in the simplest terms possible, that no bank borrowed money from this guy. It's the other way around. The defendant's rambling about personal security just deepens the confusion. This short exchange is proof that you can't bluff your way through solid evidence, no matter how many big words you throw around.
Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674, the Discover Bank versus Arnold Chavez. All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of, I talked to them in the chat. They confirmed it. And I have they gave me a bill credit for inconvenience, so that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Gopal, we did have notice that he had contacted the court and that he was unable to get on that day.
The judge moves things forward decisively. He sets a clear date for the next hearing and makes sure the defendant knows exactly what's coming. The first round of this courtroom circus ends here, but don't blink. The next hearing is even more unbelievable. Watch how the narrator teases what's ahead, a second case where the judge's patience will reach its breaking point. Get ready for an even bigger reality check.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay. All right. Here's what we're going to do. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29.
Well, I have affidavits that support what I'm saying, but I will.
Now we're deep into hearing number 2, and the excuses keep coming. This time he blames an internet outage for missing court, complete with a chat log and a refund from his provider. Nice try, but the judge isn't buying it. Despite the tech mishap, the big question remains, does he have any real defense? At all? Spoiler, he doesn't. He keeps repeating big legal buzzwords while the court zeroes in on the unpaid balance.
I want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29, will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set. All right, we're all set. Thank you,
have
Mr.
no words.
Mr. Arnold, I have ruled against you. I am allowed to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
This is the final nail in the coffin. The judge, now fully out of patience, grants the bank's motion on the spot. He calls out the defendant for making a mockery of the system and wasting everyone's time with empty arguments. The tension peaks as the judge drops a hammer. The debt is real, the excuses are worthless, and court is adjourned. This decisive moment shows what happens when fantasy law meets real consequences. We see the narrator deliver a blunt truth bomb. Despite all the fancy phrases and wild claims, the defendant's defense collapsed under its own nonsense. The judge handled it with calm authority, cutting through confusion with facts. Cases like this prove that showing up with real evidence beats conspiracy talk every time. If you enjoyed this breakdown, don't forget to like the video, subscribe to the channel, and we'll see you in the next one.